Thank you very much, Chairman Leach and Vice Chair Johnson and committee members. I appreciate the opportunity to talk to you all today. Today I'm proposing that the state of Texas add a constitutional amendment protecting the right of parents to raise their children. Over the past 100 years, federal law has outlined specific cases and has given parents the constitutionally protected right to make decisions for their children. But while case law currently protects this right, case law can be fragile and can change. Such a fundamental right deserves to be securely codified, I believe, in the Constitution itself. So the HJR is pretty short. It just constitutionally affirms a parent's inherent right to maintain the care, custody, and control of the children, to make decisions for their upbringing. The amendment prohibits the government from interfering with the parents' rights unless two very specific things. One, it's essential for the compelling government interest, and two, the actions are narrowly tailored to accomplish that need. So the purpose of the bill is essentially to codify what is existing case law as best we know, and I was asked some questions on the floor, which is great. And I think, you know, while in a way it's a simple bill, it's a short bill, I think it's also very important, and it's important that each word is looked at. I am not an attorney. I've spoken to some. We've got testimony. We've met. I've got some comments from Justice Guzman and others in terms of what we think this does. One of the main reasons to do it, frankly, is when you want to defend your parental rights right now, your lawyer has to go to case law. This will make it much more simple. To the best of my knowledge, and again, y'all can ask questions and I'll answer, and we've got people a lot smarter on the law than I am. We are not changing or giving any more rights than currently exist. We are just putting them in the Constitution that makes it easier for parents who need to use them and make it, frankly, much less expensive for parents to use those rights. So with that, I'd be happy to answer any questions that I can, and the ones I can't, I might kick to smarter people than me.
Members, any questions for Chairman Frank? Okay. You've reserved your right to close. Do you have a question? Oh, I'm sorry, Representative Dyson, I didn't see you. Representative Dyson.
Somebody might be tired.
No.
12:30 night.
Yeah.
So it's a question I was asking you on the floor earlier about that is my concern here, and have y'all looked at, are there any current laws or regulations that the state of Texas has in this sector that this constitutional amendment may cause either constitutional challenges to, or just people that will be looking into any changes of those laws?
Well, I don't think so. I think it's a great question. Obviously, CPS, and had some discussions with them on the exact words, and it's something that I think really you guys, I don't mean you guys, you should know. These are questions we need to discuss. We believe this is existing law. I believe that any of the, for instance, CPS removals, those would fit both 1 and 2. It's essential for a compelling government interest. We have found the legislature that it's a compelling government interest to remove children in certain circumstances. However, those actions also should be narrowly tailored to accomplish those needs. That's really what is my understanding of existing case law, and I'm certainly not an expert on all case law, but this is making it much clearer, but I don't believe it's expanding it.
Thank you.
Okay, members, other questions? Okay, thank you, Chairman.
All right, thank you, Chairman.
We've got 5 witnesses. I'm going to call a panel of 3 and then a panel of 2. The chair calls Steve Bresnan, Jeremy Newman, and Andrew Brown. And then Ms. Wood and Mr. Covey, you'll be on the next panel. Jeremy, let me start with you. I've got you registered on behalf of yourself and as Vice President of the Family Freedom Project, testifying for HJR 112. Is that correct?
That is correct.
All right.
Yes. Members, my name is Jeremy Newman, Vice President of the Family Freedom Project. Thank you for your time looking at this bill today. The Family Freedom Project does a lot of litigation on parental rights issues and obviously legislative work on parental rights issues. We've worked with Chairman Frank and with Chairman Hughes to draft this during the interim, and with kind of a panel of different legislative experts, judges, district judges. There's a letter being passed around from Justice Guzman, who was really involved in drafting this as well. And similar to what Chairman Frank said, the intent behind the bill is to place into the Texas Constitution rights parents already have, nothing more and nothing less. And we have 100+ years of constitutional case law that outline the rights that parents have. The issues that we are currently dealing with that we're hoping this will help solve are kind of twofold. The first one is that right now that case law is spread through over 100 years, and most of the time, in our experience, the attorneys that families can afford when these types of rights are in jeopardy are not the people who specialize in this area. Those people are expensive. And so you very often end up in situations where both the attorney and even often the judges who are dealing with these cases aren't familiar with the constitutional scope of the right that they're handling. And unless the parents can afford to get to the appellate courts, they often can't vindicate those rights. And so from that perspective, our hope is that it brings some clarity, and you don't have to have someone who's well-versed on the really voluminous case law to be able to vindicate a right that's so clearly stated in the Constitution. The second piece of it is to help ensure the longevity of that right, because right now it's in case law, and everybody knows case law is kind of fragile, right? And you can have new judicial appointments 20, 30 years from now with a different culture and different judges who have different views on the law, and those rights can evolve and change and even go away over time. And so what this bill does is it ensures that the rights parents have as they currently exist in case law are retained for future generations, and it kind of puts a bulwark against the threat that those rights would eventually possibly degrade or even go away completely over time. And Representative Dyson, as to the question that you asked, our perspective is no, that there aren't any laws on the books that are just blatantly unconstitutional that this would change. The expectation is that this would probably almost always be raised in an applied challenge, which is where the law itself is not facially unconstitutional, and the judges actually have to presume the law is constitutional. And an example of that is there was a case at the Texas Supreme Court in December, I believe, where there was a CPS case, and Justice Blackhawk actually mentioned this in his address this year. The O grounds is a way that CPS is allowed to terminate parental rights based on failure to complete services, and it doesn't necessarily have to be tied to a threat of harm to the child, just failure to complete services. And what the court found in that case was not that the law was facially unconstitutional, but that as applied in that case, it would be unconstitutional unless they read it to be really narrow, because basically their opinion was, we can't read this in a way that would allow the state to interfere in the parent-child relationship and sever that relationship if there's not any threat to the child. So we have to read it narrowly to avoid that. So that's the type of situation that it would maybe bring some clarity in, is we're not looking at situations by and large where we have whole statutes that are going to be struck down, because again, these are the same standards that everything's already subject to today. And it's really probably talking almost exclusively about applied challenges where we're making sure that as applied in a very particular case, that we're not applying it unconstitutionally. So with that, I'm happy to answer any questions.
Members, any questions for Mr. Newman? Okay, thanks.
Thank you.
Chair calls Steve Bresnan. Steve, I've got you here on behalf of the Texas Family Law Foundation testifying on HJR 112. Is that correct?
Yes, sir, Mr. Chairman.
All right, go ahead.
Thanks very much. I'm Steve Bresnan here on behalf of Texas Family Law Foundation, sitting with people who I've established friendships with, working on these very issues for a long period of time. We are neutral on the bill for the following reasons. I do think it's well established in Texas law and the United States law that parents have these rights. I don't think there's any disputing about any of that. Our members defend those rights all day, every day in the courts of this state. The neutrality comes from that the rubric here is not exactly the same language. In fact, it's quite different from the same language that's been implied in recent cases where it's a non-parent versus a parent. All the way back to the 1970s with the Amish cases, the Yoder case in particular, the Troxel case in 2000, the Dursab case in 2007, and NRA CJC in 2020. The language of those cases is that a fit parent has these rights. And that there's a presumption that a fit parent has these rights, rather than following what is a quite common description of analysis between being compelling state interest being required and being narrowly tailored. It's very common in the law, but that's not the language in the analysis that's been applied in recent years in the courts. So I'm glad to hear Jeremy make the distinction between facial challenges and as applied challenges, because each one of those cases is an as applied challenge. As I look over the statutes, I think the legislature's done a really good job of making it clear that things should be narrowly tailored. In 153.001 of the Family Code, which deals with conservatorship and child custody, it's clear that courts are supposed to make limited decisions or narrow decisions, and also 153, 193. I won't, unless you ask me to, I won't go back and read those to you. Switching over to the less run-of-the-mill but all too common cases over in the child abuse and neglect area, it's not hard at all to see that the state has a compelling interest in protecting children from abuse and neglect. So in the parent versus non-parent category, that most recently has been what's been established in the by the courts of this state, and by non-parent I would include CPS obviously in that as well. In the parent versus parent situation, it becomes a little bit dicier because someone's got to have the child on certain days of the week and for certain hours. And I suppose you could come up with an extreme case where someone was so deprived in the absence of any evidence of the time they ought to have with the child that could meet one of these constitutional challenges. But there's all kinds of remedies in the Family Code for that now. So all of that said, I want to be clear that an action of a court is state action. When it's private litigation, it's still state action because courts are making decisions. All of that said, as I look out over the Family Code, I don't find things that are objectionable on their face. I do think that there is a San Antonio Court of Appeals that applies this kind of analysis. Justice Thomas in the Troxel case, which was a plurality decision that seems to be governing most of the law in this area, advocated for this same kind of analysis, and the plurality rejected that. But as we sit here, I've not had any of our members, and I don't see from my experience in working with y'all on these bills that Texas Family Code has obvious gaps in it that would be negated or that would be vulnerable, for example, under this rubric. So I'll be happy to answer any questions.
Vice Chair Johnson.
I just want to pick up on where you said the interest of the parent versus another entity or organization versus a child. And I don't think this is at all Chairman Frank's intent, and I'm just asking out of curiosity. Having done juvenile justice issues, I have seen parents that almost treat their child like chattel or property. If we have a situation where we have legal protections where the child has a right to counsel, the child has the right to meet with counsel by themselves, and you have a parent that says, no, that's my kid, you can't do any of that, and effectively the parent feels like they have the ability to interfere with anything on the child's behalf. Do you think this constitutional amendment would, in essence, give a parent the power to intervene in that circumstance and give them a greater right to influence the child? Does that make sense?
No, I understand exactly what you're asking. To me, this has the issue, the first analysis is there a compelling state interest in the state of providing the child with counsel in a way that might be adverse to the parent's wishes? I personally can conjure up circumstances that there would be a compelling state interest in doing that, particularly the more that line gets over towards abuse and neglect, where in a way it's a conflict of interest for the parent in some of those circumstances. Then to narrowly tailor it, the right to counsel is a right that's enjoyed by human beings in most contexts. I could see how it could get out of bounds. I could see how people could use this arguments to contest that in a given case, but I think they could do that now as well. In that sense, I think this language is not frightening to me in that regard.
Thank you very much.
Thank you, Vice Chair. Yes, Representative Blowhood.
Thank you, Chairman. Mr. Bresnan, how would this constitutional amendment affect, let me read it, competing parenting decisions for the upbringing of the child? So, I mean, I guess my question, if any, and it may not, if both parents have an inherent constitutional right and they differ on their upbringing, like, would there be any effect on that? How does that work?
I think if we apply the analysis, the state has a compelling interest in making sure that kids have safe, stable homes where they get fed and they're supported and, all those kind of things that are in the interest of the child. In the family code, as you well know, the general test is best interest.
Yeah, I was going to ask.
Just before last interim, in the case of NRA CJC, there was a gap in the family code on modification cases. Texas Supreme Court read into that a constitutional fit parent presumption as part of the best interest analysis in those cases. So the courts filled in that gap where there was arguably a gap in the legislature, in the statute. There was a presumption, fit parent presumption over in the general custody statute, but it wasn't in a modification statute, and the court read that into, that's the bottom line from NRA CJC. Again, that was a parent versus non-parent. So I guess we could conjure up an extreme case where I don't think compelling state interest is a concern. Whether the remedy fashioned by the court in a given case was narrowly tailored to achieve that interest, I suppose would be fair game for lawyers to question. If someone was so deprived of a right without the evidentiary basis to stretch that, then I suppose our lawyers are going to make arguments in that regard. Again, I think they can do that today.
And I think it's safe to say that if parents disagree on parenting, that's still, I mean, that doesn't get affected. All we're doing is codifying the parents and strengthening their rights as parents. Interfamilial disagreements, I'm not talking about abuse, just parenting decisions, that's not affected by it. I mean, that still would be handled if it had to through the court system in of itself, right? Because this doesn't affect BIC.
I think, as lawyers will, we could come up with a hypothetical that would stretch the bounds
Allegedly.
of it. But I think in your garden variety everyday case, where we're deciding whether somebody gets the standard possession order or the expanded standard possession order, that courts will give other courts leeway to make those decisions in a way that meets the best interest of the child. So I'm not, I don't practice family law. I practice with y'all, whatever law I'm practicing, I'm doing right now. But we have represented family lawyers for about 15 years or so, maybe more now. And we have not, from our membership, had people filter up to us a great deal of concerns. We ask those kind of questions, and I think they're fairly comfortable that what it may change. I think early on it may very well change the arguments that people will make, but I think lawyers will be responsible in doing that. Swinging for the fences costs money, and a lot of people don't have that money to swing for the fences, as Jeremy pointed out.
Thank you.
Yes, sir.
Can I add something on your last question?
Yes, sir. Sorry.
Yeah, actually, yes, go ahead, and then I want to get to Mr. Brown.
I was just going to let you know, there's actually a body of federal case law on that exact question of what do you do when you have two fit parents who are in a dispute like that. And the way the federal courts have handled that is they said essentially, look, these are two equal rights. They effectively cancel each other out, and the way you determine is you use the best interest of the child standard, which is Steve's point, right? But the way they conceptualize that is you have two equal rights in dispute, and so they effectively cancel each other out.
Thank you. That was my concern. Perfect. Thanks.
Chair recognizes Andrew Brown. Andrew, I've got you on behalf of the Texas Public Policy Foundation, registered for HJR 112. Is that correct?
Yes, sir.
All right, go ahead.
Thank you, Chairman Leach, Vice Chair Johnson, and members of the committee. My name is Andrew Brown. I'm Vice President of Policy with the Texas Public Policy Foundation. I oversee our work on child and family policy. Thank you for the opportunity to testify in support of HJR 112. As has already been mentioned, this joint resolution would enshrine in the Texas Constitution the long recognized truth that a child's parents have the inherent and fundamental right to raise their children and make decisions for their care, education, and upbringing. And both the Supreme Court of Texas and the United States Supreme Court have consistently recognized this fundamental right for over a century now. In fact, Supreme Court Justice Sandra Day O'Connor famously wrote that, quote, "The interest of parents in the care, custody, and control of their children is perhaps the oldest of the fundamental liberty interests recognized by this court." Specifically enumerating this right in our Constitution not only safeguards it, but guarantees that Texas families for generations to come will benefit from its protections. And although we colloquially refer to these rights as parental rights, I think the legal and historical understanding of that history emphasizes that it is the children of Texas who are the ultimate beneficiaries of these rights. And Vice Chair Johnson, I think this goes to the question that you asked. When you look at the history and legal precedent around these issues, it quickly becomes clear that the rights of parents to raise their children are derived and inseparable from their duties to their children. These obligations to protect, nurture, educate, and care for their children. In his second treatise of government, English philosopher John Locke describes the parent-child relationship as a form of natural government, in which the authority of the parent is intended only for the help, instruction, and preservation of their offspring. And this is also reflected by the great American legal scholar James Kent, who wrote in 1827 that the rights and duties of parents are so well secured by the strength of natural affection that it seldom requires to be enforced by human laws. And so when we see the way that parental rights are, and in fact family rights are applied, we recognize that parents only enjoy these rights so far as they exist to meet the obligation that that parent has to care for and nurture and educate that child. By safeguarding this all-important relationship through HJR 112, we can secure a prosperous foundation for Texas children for generations to come. Thank you all for your time, and happy to answer any questions you may have.
Members, any questions for Mr. Brown? All right. You do? Representative Flores.
I find that a little circular, in fact, because, I mean, what if you have bad parents? I mean, and they don't allow their, I mean, I'm concerned that a child should have an attorney ad litem or something, because you may have some parents who, you would think that they would, by nature, have the best interests of their child's at heart. However, they may not in a perfect world. I mean, so I think it's really important that the rights of children are also protected and recognized, that sometimes if you're growing up, and no offense, a fundamentalist family, and they're or a case where they treat their children like their property, you want to make sure that somehow that information makes its way to the court so that these children are protected.
Right, and that's why the constitutional amendment and the law itself for over 100 years reflects that there must be a compelling state interest. It's not saying that this is an absolute shield and protects against decisions that would operate contrary to that parent's obligation to care for, nurture, and protect their children. This recognizes that that occasionally, tragically, sometimes does happen. And it creates the opportunity and the avenue for the state to intervene when it is necessary to protect those children. But what it also recognizes is the state should be very limited in the interference that it can exert in the private realm of the family. And so the wording of this amendment accurately reflects the jurisprudence of not just this country, but the Western civilization, in the understanding of the parent-child relationship and how that is insulated from overreach from government.
Well, provided that there is a mechanism or a way for the best interest of the child to get known if it's being, not put forth by the parents. I mean, you got to be able to, somebody's got to be able to interfere. And somehow that information needs to make its way to give the state a compelling state interest. They can't just know it on their own. So and maybe I'm making a dumb argument, but I would
Not
just
at all.
think that somebody has to have, the child needs to be protected in and of themselves. They need to have certain rights that are inherent to them.
Right. No, and your concerns are well-founded and well taken, and the structures that we have in place currently through, for example, the Department of Family and Protective Services, are fully constitutional even when you apply this framework. That's been consistently upheld. Essentially, as Representative Frank mentioned, we are not creating any new right that has not existed for centuries. We're merely codifying that case law into a clear statement within the Texas Constitution in order to preserve that from erosion in the future.
Thank you, Representative Flores. Members, any other questions for this panel of witnesses? All right, thank you, gentlemen.
Thank you.
Okay, we've had some other people registered to testify. The chair calls Cecilia Wood, Jonathan Covey, John Schmood, and then the final panel of witnesses will be Sarah Lindley Bailey and Amy Lee Owen Klossel. Ms. Wood, let's start with you. Welcome back to the committee. It's good to see you. I have you registered on behalf of yourself, testifying for HJR 112. Is that correct?
I'm sorry.
No, Cecilia Wood.
I thought you were talking
No,
to him.
maybe I should be more clear. I'll slow down.
Okay.
The chair recognizes Cecilia Wood on behalf of yourself, registered for HJR 112. Is that correct?
That is correct.
Okay,
And
go
I
ahead.
should recognize my name. Thank you, Chairman.
Sure.
My name is Cecilia Wood. I have been practicing in Texas. I've been licensed in Texas since 1986, and I've been board certified in family law since 1993. And I have tried a lot of cases with a lot of different scenarios. As I was preparing for this again this morning, I read it again, CJC, which Mr. Bresnan referenced, and as I read the comment from them, it was like I couldn't have said it any better, so I'll just use their comment. The United States Supreme Court has long held that the Constitution protects the fundamental rights of parents to make decisions concerning the care, custody, and control of their children. This recognition stems from the strong tradition of parental concern for the nurture and the upbringing of their children. The Supreme Court's jurisprudence rejects any notion that a child is a mere chattel or creature of the state, but instead holds that parents generally have the right, coupled with the high duty, to recognize and prepare their own children for additional obligations. Accordingly, the care, custody, and control and nurture of the children reside first in the parents, whose primary function and freedom include preparations for obligations that the state can neither supply nor hinder. And this is not a new concept. The oldest case I found in Texas dates back to 1900, so it goes back even farther than the federal jurisprudence, where the state recognized this right. Getting courts to recognize this rights, getting laws to recognize the rights, these inherent rights that come by virtue of being a parent, has been an uphill battle. And I think that Mr. Bresnan was correct. We have a lot of statutes now in the family code that recognize that and that make reference to it. And so we've come a long way. We have a lot of case law that has been litigated in different, as a matter of fact, I gave you a very short outline because as I started going back through all my old briefs and things that I had written in 38 years, it's like, yeah, I can't bring all that to the courthouse, but you can call me and I can send you whatever you need. I think everybody's done a good job of kind of explaining how the history came along on this. So I want to make one comment that we not only want the right in the Constitution, because as we know, the feds could change things and then the courts could change things. We want the right in the Constitution. We also, some people don't like that we've put in the strict scrutiny test because they think that gives the government powers that doesn't give them any other powers than what they have right now. It just means that we're not going to change that test or ever lower that test. And even if we other courts do away with strict scrutiny in other areas. This, we're going to be looking out for, and in part because that is what protects the children, Representative Flores. It's something as a practical matter, because I have been doing this for 38 years. If one parent is, over controlling a child, I promise you, the other party will bring that to the court's attention, at which point, an amicus attorney or whatever would be appointed to bring out the child's interest. I've never seen in a contest where the other party had something bad to say, didn't say it. So I get your concern, but I think that the nature of the conflict brings it out. Mr. Bresnan said we can come up with a situation. I had a situation where two parents were named as joint managing conservators. They both wanted to appeal because they didn't like certain things. And the judge took both parents back into, or their attorneys, we went back into chambers so we weren't on the records, and said, well, if they want to have this hearing for temporary orders pending appeal, that's fine. But if they do, I'm going to take the kid and send him to a military school as far away as possible. Well, neither attorney could prove that was said, right? So the parents worked that out themselves. So I agree, there is federal law that basically, the way you think it through, it's like a cancel out. But the judge, I would say the only limitation on the judge and two fit parents is to do something like that, way outside of what either fit parent had decided was a good idea for their child. The last thing that I think that is important about this is that things change, pendulum swing. Before I couldn't find a case older than 1900, and that case actually cited other states because this wasn't on the government's radar that far back. So we never want parents, and because traditionally we feel that parents provide good things for their children, and so you have a right to liberty, but if you break the law, you're going to jail. And if you do something that is not adequately caring for your child, you might forfeit your rights. But by doing this, we give the citizens, because this is an amendment, we give the citizens of the state an opportunity to vote and to protect and preserve these rights for generations to come. Thank you.
Thank you, Ms. Wood. Members, any questions? Okay, thank you. Chair calls Jonathan Covey. Jonathan, I have you here on behalf of Texas Values, registered for HJR 112.
Yes, sir.
All right, go ahead.
Mr. Chairman, great to see you. Great to be back in your committee this session.
as well.
My name is Jonathan Covey, Director of Policy for Texas Values, testifying in favor of HJR 112. I think the previous panel and Ms. Wood did a great job. This is just basically a restatement of law as we already have it. And so we support this bill, and we support it for two reasons. One, for longevity, because parental rights are grounded in the 14th Amendment in cases like Troxel and Santosky and Lassiter and Prince, and they're too important to be left in a body of federal case law. They need to be in our Constitution. And then secondly, for clarity, because there are times when trial courts may need that clarity. Trial court litigants, as Ms. Wood was talking about, need that clarity as well. So we appreciate Representative Frank bringing this bill. I do see this being mostly used during applied challenges where the law is not facially unconstitutional. So we just ask you to support this measure, and thank you for bringing it up.
Okay, thank you, Mr. Covey. Members, any questions? Okay. Thank you. The chair calls John Schmood. John, I have you here on behalf of yourself, registered for HJR 112. Is that correct?
That's correct.
All right,
and I'm also the Legislative and Policy Director of the Family Freedom Project.
Okay, do you want, I've just got you here on behalf of yourself. I don't have
Right.
your
That's
title.
fine.
Are you sure that's okay?
That's fine.
Okay,
Yeah,
all right.
absolutely. Thank you, Mr. Chairman, and honorable members of this committee. I should mention that I am a former state district judge. I was the judge of the 247th Family District Court in Harris County. So in that role, I presided over more than 13,000 cases, and I just figured members of this committee might want to hear from someone who actually was a family court judge. Just to reemphasize, HJR 112, of course, I know it's been repeated over and over again this afternoon, does not change our current law one bit at all. It merely enshrines into our state constitution the protection of one of the most fundamental liberties, one of the oldest liberties, deeply rooted in the history and traditions of our great state and our great nation, the right to exercise the custody, care, and control of one's child. The fundamental concept of liberty, which should unite all federal, state, and local governments, excludes any general power of the state to inject itself into the private realm of the family absent a compelling state interest and absent an interference that's narrowly tailored to remedy that compelling state interest. For more than 100 years, our nation's highest court has recognized the right to oversee the care, custody, and control of one's child as a fundamental right, secured by the Due Process Clause of the 14th Amendment to the United States Constitution. Ms. Wood quoted from, I recognize the quote, she quoted from Pierce versus Society of Sisters, which was actually a case that was decided by the U.S. Supreme Court in 1925. That's how old this fundamental liberty is. It's a component of substantive due process. In Washington versus Glucksberg, the court held that the 14th Amendment's Due Process Clause has a substantive component that provides heightened protection against government interference with certain fundamental rights and liberties, including parents' fundamental right to make decisions concerning the care, custody, and control of one's child. The court further stated that in a long line of cases, we've held that in addition to the specific freedoms protected by the Bill of Rights, the liberty specially protected by the Due Process Clause includes the right to direct the upbringing of one's children. Our nation's case laws regularly observe that the Due Process Clause of the 14th Amendment specially protects those fundamental rights and liberties which are objectively, specifically rooted in our nation's history and tradition. The right to the custody, care, and control of one's child is one of those most basic rights, one of the first rights recognized under substantive due process that is deeply rooted in our nation's history and tradition. More than 100 years of federal and state constitutional jurisprudence has consistently maintained that there's a presumption, and this is eloquently stated in Troxel versus Granville, which was a Supreme Court decision in 2000, that fit parents act in their children's best interest. And there's normally no reason for the state to inject itself into the private realm of the family absent a compelling state interest and provided that that interest is narrowly tailored to accomplish that compelling interest. HJR 112 very accurately memorializes the protection of a fundamental liberty, the right to exercise the care, custody, and control of one's child and to make decisions for the upbringing of one's child. The protection of this fundamental liberty is entirely consistent with state and federal constitutional jurisprudence. Also, the strict scrutiny test that is set forth in the bill very accurately sets out the test that's already in place whenever there is a state interference with a fundamental right protected under substantive due process. Our courts have made it clear that strict scrutiny is the proper test when dealing with a fundamental liberty under substantive due process, and HJR 112 perfectly memorializes that two-prong requirement for strict scrutiny. Again, in conclusion, HJR 112 doesn't change our current law at all. It merely enshrines into our state's highest governing document the protection of one of the most basic and long-held fundamental liberties that is so deeply rooted in our nation's history and in the traditions and history of our great state. Thank you very much for the opportunity to testify. I'm happy to answer any questions that anyone has.
Okay, Judge, thank you so much for that testimony. Members, any questions for this panel? All right, thank you. Appreciate you all being here.
Thank you.
The chair will thank you. It does come and go. Okay. Two other witnesses on this bill. The chair calls Sarah Lindley Bailey and Amy Lee Owen Clausel. Ms. Bailey, let's start with you. I've got you here registered as Sarah Lindley Bailey on behalf of yourself, testifying for HJR 112. Is that right?
Yes, sir.
Go ahead.
Good afternoon, Mr. Chairman Leach and honorable committee members. My name is Sarah Lindley Bailey, and I am here to advocate for House Joint Resolution 112, which aims to protect parental rights in the context of rare childhood illnesses. As a mother of a child who will forever be 4 years old, I understand this reality all too well. My toddler was a warrior. During Taylor's battle with cancer, I pursued every possible care avenue, yet my parental rights were often overlooked. I lived in fear, feeling pressured and intimidated from medical professionals and police officers. This is a reality that people live with in the hospital. Many parents face similar situations once their child is diagnosed with rare conditions. Do as the doctors say, or your child can be taken away. This is what I refer to as medical kidnapping. My child was on several medications, gabapentin, morphine, and fentanyl. It's a deadly combination, and yet I found out 3 days too late. I read medical studies as if her life depended on it, because it did. We lived in the hospital for practically half a year. I wanted to fire a doctor on day one for molesting my child, and I was told I did not have a choice in the matter. She punched him in the face. We were never going to have a professional relationship after that. And yet he denied blood cultures, he denied other issues. I was refused Benadryl, but again, morphine, fentanyl, and gabapentin were pushed. Child abuse physicians will get involved and make you look like you're the worst parent in the world if you are not doing as what they say. Again, medical kidnapping happens. Current laws do not sufficiently protect parental rights within the hospitals, often labeling us as neglectful or seeking alternative treatments or second opinions. Currently, I'm assisting another mother who lost her rights without going to court while her 6-year-old is on hospice. This is not okay. One mother who testified yesterday, her daughter was medically kidnapped, spending nearly $100,000 to regain her child's back into her arms to obtain her parental rights. This is not Texas. That is not freedom. Parents should have the empowerment to make the best decisions for their children and not create fear, especially in the hospitals. I urge the committee to support House Joint Resolution 112 so that parental authority remains respected and the families can navigate medical challenges without undue fear or coercion. Thank you for considering this crucial legislation, and thank you, Representative Frank, for authoring.
Thank you, Ms. Bailey. Members, any questions? All right, thank you. The chair calls Amy Lee Owen
Clazel.
Clazel.
That's okay. I might screw up your name too.
Amy Lee Owen Clazel. I have you here registered on behalf of yourself, testifying for HJR 112. Is that correct?
That's correct.
All right, thank you. Go ahead.
Yes. Good afternoon, Mr. Chairman Lynch and honorable committee members. Thank you for being here today and hearing everybody's testimonies. On this important legislation day, my name is Amy Lee Owen Clazel. I'm from Moulton, Texas, in Lavaca County. I am for House Joint Resolution 112. I'm a mother of twin 5-year-old girls. I've had zero contact with them for over 10 months. It's heart-wrenching. I'm sorry.
It's okay. Take your time. Michael, can you grab those tissues for me?
Parent rights is something that's excuse me. Thank you. Parent rights is something that's supposed to be between two parents, not between the government, CPS, the legal system, your mama, your daddy, your mother-in-law, your cousins. It should be between both parents. We know what's right for our kids. They share our DNA. We know what's best for kids because we've been through it. We know how they are. We're instilled in them. I'm a victim of parent alienation. I filed for divorce back in November 2023 to get out of a toxic situation. My ex, Cody J., got mad at me for filing for divorce and used our broken legal system to punish me. He got the legal system involved. He went to the law enforcement, made false allegations that I've been beating him up for 15 years. He contacted CPS, making false allegations that I was unstable, I was a danger to my daughters, and the psychological abuse that I was put through and my daughters were put through and other parents that are put through the CPS system and our legal system is horrible, is traumatizing, and it's unnecessary. I support the Joint Resolution 112 to keep government out of our families and our marriages and protect our rights as parents and to protect our children and their well-being. This system really traumatized me and my daughters, and it's going to take years to correct this. And like I said, I'm not the only victim. Our family's not the only victim. There's many. I thank you, committee, for hearing my testimony today, and I ask for you to vote favor in House Joint Resolution 112. Thank you, State Representatives Frank, for authorizing this important piece of legislation. Thank you.
Thank you for sharing your story.
Yes.
Members, are there any questions for either of these two witnesses? Okay, thank you sincerely.
Thank you.
Does anyone else wish to testify on, for, or against HJR 112? Seeing none, the chair recognizes Chairman Frank to close on the joint resolution.
Thank you, Chairman. Just I'll try to go quickly, but I wanted to touch on just a couple things real quick. Representative Flores, I don't believe any of this will make it more difficult to remove a child in those situations where you need to. I'm happy to talk to you more on the floor. I don't think there's anything, this doesn't give actually more rights, but it does codify them. And I think, you know, when you look at it, we do a lot of things every session that make it more and more complex to assert your rights. This one actually makes it more simple. It takes all of the case law and simplifies it so that if somebody actually needs to assert their rights, and frankly makes it a little more easy for government to say, here's exactly the 2 criteria you have to have before you intervene. Doesn't stop you from intervening, it just makes it, I think, more clear. I will be happy to talk to either of those ladies afterwards to try to walk them through. That's been my life for the last 6 years, is working through the CPS world, but I don't think it really is impacted by this bill. But with that, Chairman, if anybody has any questions, I'd be happy to answer them. If not, I'd be even happier to just close.
Members, any questions for Chairman Frank? Okay.
All right, thank you. Appreciate
Thanks.
you hearing it. Appreciate y'all's support.
Of course, thank you. The chair will leave HJR 112 pending at this time.